Okay, good morning all. Last week we discussed about patent and its intricacies. Okay, just like say what is patent, why patent, then what criteria required for something to be patentable, what are not patentable. Then you have learnt about novelty, you have learnt about prior art, you have learnt about prior art search, including patent and non-patent literature search. I have given you an overview of patent classification based on international patent classification. Okay, I have given an idea of inventive steps, just like say inventive steps little bit tricky compared to the novelty, and I referred that for inventive steps you can club to prior art. For novelty is all features of the invention should be present in single prior art. Okay, so what is the difference? If I ask what is the difference between novelty and inventive steps, so you may refer that novelty means all the features of the invention should be present in a single prior art. For destruction of the novelty, for destruction of the inventive steps, the person skilled in the art can club the prior art and apply either problem solution approach or TSM test as applicable in US courts or US PTO for judging the inventive steps criteria. So those are the inventive steps, and industrial applicability, that another of the criteria that I referred that invention should have capacity to be used in an industry. That industry, as court has defined industry, including agriculture as industries. So as should be used in an industry. The invention should be used in an industry. The industry includes agriculture industry. That was the things. And also I referred that what are not patentable in India and what are not patentable in other jurisdiction, majority mostly US and EP, because majority of the people try to file protect the invention either US or European country, considering the market part. Okay, so now that was the just like say the discussion that was held in the last week. Just I giving you a recapitulation of all the last week discussion. Now I will proceed further because we have to go ahead. Okay, I think you have completed the last week assignments. Then if you have any question clarification, you can also put up those things. So now let's see. I'll go ahead with the next today's discussion. This is also important, specifically as an engineers and technologist. Although the last week discussion is mostly important, but why to miss some other things also, just like say who can how the patent application be filed, how the patent application be proceed, and how the patent applications be maintained, how the patent application, what is the utility of the patent application if I say somehow not utilized my rights, if somebody enforce or somebody infringe my rights. All those things we can discuss in this week. Let's say start the discussion with the things that patent filing procedure, and we are considering only with reference to India now. Okay, so now so let's say patent filing procedure. If I state, so immediately the questions will come, who can file patent application, who can file patent application. Let's say patent, or let's say you last week you already came to know that what are the criteria required for patent applications. So now say let's say what is invention you came to know, what invention is not patentable you to know. Now, let us say you have I am considering that you have generated a patentable invention. So, now what will be the workflow for that? So whether then questions will come up to your mind immediately, whether I can file patent application, or so you means you are the inventors, or I have to file the patent application through somebody, or I have the sufficient knowledge to file the patent applications or not. So those are the questions immediately will come to your mind. So the Act has clarified those things in the Indian Patent Act. If you find out section 6 of Indian Patent Act referred who can file a patent application in India. So they have referred who can file patent applications. So just like I have referred here, first and true inventors. Okay, so first and true inventors. Let's say you invented last class discussion. If you consider that some fluid for maybe for magnetohydrodynamics. So that fluid you are the inventors. So whether you will be considered first and true inventors, that part I will explain. So who can file? First and true inventors, or his assignee or assignee of the inventors. Assignee of inventors means first and true inventor or his assignee or legal representative. You should read it on that way. First and true inventors or his assignee or legal representative of the first and true inventor. So either singularly or in jointly. So first and true inventors can file patent applications, or he can assign the right to file patent application to somebody, or some legal representative who got the right to file patent application, maybe just like, so let's say he has given by virtue of some legal instrument got the right to file patent applications. So legal representative can file patent application on behalf of first and on true inventors. Okay, so now you have come across the three terms, that first and true inventor or his assignee or legal representative. Let's say I will try to explain all these three terms based on different example and case studies. So who will be considered an first and true inventor? So here the two word along with the inventor qualifying the inventors, first and true. True means you represent true by, if you interpret the true, true means not false. First means not second, means who he has invented the invented that product or process first, and he is the true, not wrongfully obtained from anybody. So that person can file, will be considered as first and true inventors. Let's say there are series of case studies or example can be created on that part. Let's say the professors along with, and let's say two professors, Professor Roy and Professor Das went to excursion along with his research scholar, let's say Ram, Sham and Jodu. So they went to excursion, and when they were passing, they went to a particular field. They found out lots of solid waste lying there, and the area is completely dirty. Lots of smell have been coming out from that area, and water is ultimately leaching those solid waste including maybe some toxic elements that is also mixing with the waters, rainwaters, and say that have been carried to the field. Okay, so they found out the problem with, they found that okay, this solid waste is creating what, the creating a obnoxious gas. The solid waste is creating pollution to the soil. Solid waste is creating, so pollution to the soil, pollution to the water. So ultimately that so all type of pollution, let's say soil, water, and say gaseous environmental gaseous pollution have been happening on that solid waste. But the solid waste can be used as a potential source of energy. So they thought about that solid waste. How can we solve the problem on the solid waste? So the all together sit. Mr. Roy was chemist, Professor Das was a mechanical engineer, Ram, Sham and Jodu are the research scholar working under them. They sit together and ultimately they came up with a process, a novel process, I will say consider novel process for utilizing of the solid waste for generation of gases, means biogas in the form of biogas. So Professor Das has designed a biogasifier. Professor Rai was ultimately instrumental for say how that what will be the way that say that solid waste can be can generate the gas, biogas, and Professor Ram, Sham and Jodu all over working in that field, and but that by virtue of that they generated a system for converting. So invention came up, let us say system for conversion of solid waste to energy, solid waste to energy. Okay. So by biogasifier they are ultimately converting into energy. So if I consider this invention, so in this invention, so who has the contributed? Professor Roy, Professor Das, Ram, Sham, Jodu. Okay. So if I not able to distinguish the contribution of all those 5 members, then all 5 will be considered as first and true inventor for this invention. Okay. So now if I consider a situation, say another case study. So first and true inventor understood. So if I able to distinguish the contribution of others, then we may consider them as co-inventors. If I don't able to distinguish their contribution, then they will be the inventors. Okay, inventors. Okay. So now consider a situation. When they got the idea, but ultimately that have been fabricated, designed with the help of technical assistance or some vendors, because let us say Mr. Das has designed the gasifier, he has given to Mr. X to fabricate that gasifier. Mr. Roy has used his technical assistant to for the synthesis of that for the production of the biogas. So now whether the questions will lies that whether Mr. X who has been used by Mr. Das, and whether Mr. Y who has been used by Professor Roy for production as a technical assistant, and Professor Mr. X as a fabricator for gasifier, whether they also will be considered as inventor or not. So what do you think, whether they will be considered inventors or not? So based on that, just like say that the different types of different cases came up in the courts. So they came up with a solution that they will be considered the contribution of each member in respect of the invention. If they say the contribution of all, let us say Mr. X, Mr. Y, Professor Roy, Professor Das, Ram, Sham, Jodu, all having the substantial contribution, then they will be treated as inventor along with say others members. So Mr. X and Mr. Y will be treated as inventor if their contribution is substantial. So you may ask me, what do you mean by substantial contribution? So substantial contribution means without their contribution, invention will not complete. Means some, at least some aspect of say intellectual involvement of Mr. X or Mr. Y is there. So, their contribution is not mere robotic contribution, such like let us say Mr. X has not simply follows the instruction whatever provided by Professor Rai for the chemical reactions. Mr. Y has not followed the design whatever Professor Das has given him to fabricate. He has involved his say intellectual to somehow modify that design. So, and that design ultimately lead to the better production of the biogas. In that case, Mr. Y has also contributed substantially for the that system or invented system. So, Mr. Y also will be considered inventor. Similarly, Mr. X has not followed the instruction provided by Professor Roy. He has just changed the temperature or other condition of the reaction for production of the biogas. So, then Mr. Y also have contributed substantially for generating the biogas. So, Mr. X also will be considered as inventor. So, question lies. So, who will be considered two and first inventors? Who has contributed substantially to generate that invention, substantially, how will you decide? Substantially means without their contribution, invention will not contribute. Contribution means what type of contribution? Physical contribution? No, means intellectual contribution. Physical contribution I will consider a mere robotic contribution. Okay. So, without their intellectual contribution, if invention is not complete, then they will be considered as first and true inventors. Then who can be considered as assignee of the inventor? Let us say you have invented something, but you are working in an organization. So, what organization policy suggested? Whatever you will create or invent, you have to assign that thing to the institute. So, in that case, the assignee will be the institute or organization where you are working, because their policy suggested, organization policy suggested, whatever you will create during your course of employment or course of study, you have to assign that thing to the institute, and institute in return will provide some sorts of reward or incentive. So, in that case, that institute will be your assignee. So, this is based on the employee-employer contract. In several cases also, you may also without independently going to the filing patent office, you may also think about, okay, let it assign to some company or some organization. So, you can execute an assignment deed or assignment agreement with the company, then they will be the assignee, and the assignee will file a patent application as an applicant. So, you got the thing. So, assignee of what? All the true and first inventors. So, here you have to question lies that assignee means, okay, Mr. all say how many player involved here in this situation? 5 plus 2, 7 player. So, assignment has to be done by all 7 player to the organization. Otherwise, his rights is not complete with reference to that invention. So, this is the one situation. You have to be cautious that assignment should be done by all the first and true inventors who has generated that invention. Otherwise, the title or say for application as provided to that say assignee is not complete. So, you understood what is assignee means? Assignee of what? Assignee of the inventor. What is assignee? Assignee is by virtue of some deed of assignment, or you may consider by means of some assignment agreement. Who is assigning? First and true inventor is assigning. For what? Assigning to file, may be right with reference to filing the patent applications. Okay. So, now another part is so assignee part you understood based on employee-employer agreement or based on some assignment deed. So, first and true inventor can execute an assignment deed or agreement. So, who is considered as legal representative? Okay. So, let us say consider a situation, let us say Mr. X has invented something. Okay. So, now during that process Mr. X has passed away, but he has executed some legal instrument to pass the all his legal or equitable rights to somebody. So, by virtue of some that legal instrument, So legal representatives can get the rights to file patent applications. So the situation, one situation may arise just like a person dies, but he has given the rights based on some legal instruments to file the patent application to a representative. So he will be considered as legal representative. Also some cases we execute power of attorney to file patent applications through some attorney. Such cases also we use the attorney, give some to power by means of general power of attorney to file patent applications or execute on behalf of the applicant. So these are the two situations we may consider as legal representative, mostly with reference to the situation where the person dies. Maybe in this cases such a situation, if assignee, let us say company, in that case also maybe we may use the term legal representative. Assignee can ultimately, let us say a company dissolution, devolutions, all those kinds of situations may also that legal representative can be interpreted or used. Okay, so you got the things who can file patent application, the three part. Okay, so now the question arises, let us say you are from Ahmedabad. So where you will file your address of service is Ahmedabad, your place of residence is Ahmedabad, your place of business is also Ahmedabad. So where you will file the patent applications. So then that Indian patent say IPO has divided into the 4 jurisdiction for filing of patent with respect to patent filing: Kolkata, Mumbai, Chennai, Delhi, and they have also divided the jurisdiction for, let us say, Mumbai, Maharashtra, Gujarat, Madhya Pradesh, Goa, Daman, Diu, Dadra, Nagar Haveli, Chandigarh, Chhattisgarh are the jurisdiction. For Delhi, these are the jurisdiction as referred in the slides. So you are from Ahmedabad. So what jurisdiction will you use? You will use Mumbai Patent Office jurisdiction. Mumbai Patent Office jurisdiction. You will use Mumbai Patent Office because you are from Gujarat state. So you will file patent application in Gujarat Patent Office. So you got the thing. You are the first and to inventor. You are filing patent application. Where you are filing patent application, that also you got the idea. Now, so filing when you to file have to file patent applications. So the patent application should be filed immediately, because otherwise you may lose the novelty of invention. Just last class I discussed about that ballpoint pen cases, about that car testing in over a road. So instead of that losing the novelty of your invention, you should go to file patent applications. If you think about your patent application is not complete, there also routes are available. If you that's called sometimes you call provisional routes, then complete patent specification route. So I will suggest you should go and file patent application whenever you are thinking that your invention have some potential, commercial potential, and so you should go and file patent application, even that invention is not complete in all respects. You may have to require some time to complete that invention, but don't wait for that. You should go and proceed and file patent application using the provisional routes. Okay. So because inadvertent delay of invention by inventor may damage novelty of the invention. Okay. So I already mentioned that who can file the patent application, where to file the patent applications. You can file and refer that say to you that if your invention is also not complete, you can go and file patent application. So there you can use the two route, provisional and another you consider is complete. Okay. So if your invention is not complete in all respects, you are thinking about further improvement and other, but you are thinking about that concept has huge potentiality, and so better to protect it, to get some date, or sometimes we call priority date. So in that case you should file a patent application using the provisional applications route, or sometimes we call provisional specification route. In that route you give that give the details of the concept, along with that whatever data or working data or description you have generated till date, and so by that way you will somehow getting a priority. So then what is the route? So, then if you getting the priority, but you have to complete your invention within 12 months. So, a complete specification, provisional specification is giving you a priority to complete your invention within 12 months. If you do not able to complete within 12 months, so then you will lose the priority. Okay. But there is a procedure we call post dating. You are thinking about, say, you file a patent application today, but in 11th month you are thinking about that, okay, I will not able to complete my invention within a month. In that case, you withdraw your first provisional applications and file a phrase. But there is also chance that within that, say, 0 to 11 month time frame, if somebody came up with the same or similar type of invention, then there is a risk. Okay. So, if you filed in that between, let us say, 6th month, you have filed in 0th month, somebody filed in 6th month, so and you are withdrawing in 11th month. So, 6th month persons will get priority over your 11th month, where you are filing another fresh provisional patent application. You got the idea? So, better not to post date your invention or withdraw your provisional applications. So, we file, you should get file a provisional patent applications, file the provisional application, then you file within a 12 months a complete patent, complete specification. So, provisional. So, your filing date will be considered from the date of filing provisional patent applications. Okay. So, provisional patent application will be considered the date of filing, means your rights of, that is whatever I referred as 20 years time, 20 years rights will start from the date of filing the patent applications. Okay. So, how will you file the patent application? Where you will file the patent application? When to file the patent applications? You got little bit idea. Then what will be the content of your patent application? That part I am mentioning here. That applicant is such that. So, you have to file an abroad filing part status of that part I will explain later on. A filing a complete specification, then provisional or complete power of attorney. If you are giving by means of legal representative, you may give by to the in the form of power of attorney. Okay. So, let us say summarize whatever discussed now. You have got an idea who can file patent application, how will determine who is the true and first inventors, how will you consider who is the assignee, how will you consider legal representative part, what are the different hypothetical situation or case study we can create out of those, all those things you got an idea. Then you got the idea where to file the patent applications, what are the jurisdictions have been prescribed by Indian Patent Office for filing the patent applications, that is decided based on your place of business, address of service, that which jurisdiction will be applicable to for you to file the patent applications. So, you got the idea of that. Now, what will be the advantages of the provisional patent applications, the provisional route, and what is the complete specification? Also, you got little bit idea, although this part may require further analysis, all the things, but you understood. If you what the thing that invention, if provisional, if you think about the invention is not complete at this stage, you should go for a provisional patent applications. So, provisional patent application will not give details of your invention, because your invention is not complete. So, you may ask me whether in the complete specification that I can change my scope. I will say no. If your invention is reference to the light and the light, so you cannot add in a complete specification a fan. So, that is, but if you think about fan and light, I can club together, say, illuminated fan light. So, within the same inventive concept in legal term we call, then you may consider illuminated fan light, so a fan illuminated light or something like that, then it will be possible. So, the same inventive concept means with the working of the fan, I can also link the working of the lamp, then fan and lamp can be linked. If both are independent, then you cannot link. Okay. So, within the scope of your provisional specification, you have to file the complete specification. This part you have to remember. Within the scope of your complete specification, provisional specification, you have to file the complete specification. Okay. So, you may file a 2, 3 or more number of provisional specification for different attributes of the of your concept. There is no problem. Okay. There is no problem. You can find different attributes of that. Okay. Let us say from you first you file fan, then fan you linked with a light, then like say linked with a sensor, like this way altogether you may file a provisional specification, and then all clubbing all the provisional specification, you are filing a complete specification. So, you have provisional specification and complete specification, how it links, we should come within the same inventive concept, which concept you have been stated in the provisional first provisional specification, and complete specification will be within the scope of that provisional specification. Okay. So, let us say how to file patent application you also got. Okay. So, now we are stopping it here for today. We will further continue with subsequent steps involved with reference to your invention to get some rights from a particular jurisdiction. Okay.